The development phase of an entertainment project is filled with numerous agreements. These agreements can make or break the long-term financial health of a producer. If done wrong, the producer can forfeit their rights, but if done right, they can successfully produce a project that is fruitful for all involved. I want to share the 3 elements producers need to focus on in order to protect themselves in connection with an attachment agreement. The first element is the work for hire rights clause. One of the benefits of an attachment agreement is getting key talent to provide services during the development stage of a project. For example, the producers will request that the talent assist with the creation of the development materials for the project, such as a proof of concept short film. It is important that the producer makes clear to the talent that their contributions to the proof of concept and other development materials are work made for hire. This means that the producer shall exclusively own the copyright and all rights in and to the results and proceeds of the talent's work in connection with the development materials. In the work for hire rights clause, producers should include language that states that the talent grants producer the right to take motion and still pictures of the talent and to utilize talent's name, image, likeness in the development materials and in the project. The language of the work for hire rights clause is critical for producers. The second element for producers to focus on is the representation and warranties clause. The key for producers in an attachment agreement is to get the talent committed to the project and to see it through to production. Producers should have talent explicitly state their commitment to the project, and the way to accomplish that is to have thorough language in the representation and warranties clause. Namely, it should state what the legal expectations are of the talent in terms of time commitment, attending meetings, and being available to assist with development materials. The third element that producers need to focus on in their attachment agreements is the control clause. Essentially, the control clause should state which party will have the right to make creative, financial, and business decisions relating to the project. Producers who naturally own the rights to the project should of course state that all rights and authority with respect to financial and business decisions of the project rest solely with the producer. Now, this isn't to say talent should have zero role to play in making decisions on the project, just needs to be clear that the producer has final creative and business control. Talent will most likely request to have meaningful consultation rights regarding creative decisions to the project. Producers should be comfortable including this language because you always want to have open communication with your talent on creative elements. This language in a control clause appeases the talent who want to have consultation power on creative decisions, while at the same time strengthens the power and authority of the producer who is ultimately running the project. Focus on these 3 key elements of attachment agreements, and you will protect yourself as a producer in the development phase of a project. If you are a producer, I would always recommend having your attorney draft the attachment agreement to ensure you are taken care of both now and in the future. Protect yourself.